Hello, my name is Vivian Arts. I'm the chair of the International Regulatory Strategy Group Data Working Group, and I'm delighted to welcome you today to the AFME, the Association for Financial Markets in Europe, Virtual Compliance and Legal Conference 2020. Yes, we are virtual. The session today is focusing on recent developments in the world of data and what do they mean for the financial services firms. I'm delighted today to be joined by Linda Mikula, who is Head of Privacy Legal EMEA and Assistant General Counsel at Citi. She's the regional lead and subject matter expert for EMEA on all GDPR and privacy issues globally. I'm also delighted to be joined by Anna Buchter, who is Head of the Policy and Consultation Unit at the European Data Protection Supervisor. She leads the work of the EDPS on legislative advice to the European Commission and other EU institutions and bodies. So in today's session, we will be looking at recent developments in the world of data. And if you've been reading the news, you'll know that the biggest decision is in relation to Schrems II. So on the 16th of July this year, the CJEU made a decision that the Privacy Shield, which is the arrangement between the EU and the US to allow the transfer of personal data from the EU to the US, was rendered invalid, null and void. So it is a huge decision, and we would suggest that probably it is the biggest decision since the Safe Harbor was invalidated in 2015. So the CJEU decision said two things. It first of all said that the Privacy Shield is no longer valid, but it also made a statement with regard to standard contractual clauses, which is another very significant mechanism used by firms to transfer data internationally. And in relation to standard contractual clauses, the statement was that they are still valid, which came as a relief to many firms, but that additional measures are required in order to continue using them on a go-forward basis. So in today's discussion, I'd like to start with Anna, to ask you, Anna, in relation to this very, very significant decision, what do you think were the main drivers for determining that the Privacy Shield is no longer a valid mechanism for the transfer of data between the EU and the US? And do you think that there is an opportunity for a version 3 of the Privacy Shield? After all, we had Safe Harbor, then we had the Privacy Shield. Is there a version 3 on the horizon? Anna.
Thank you very much, Vivian, and good morning, everyone. I'm very happy to be here with you and to be part of this discussion. Well, you mentioned that the Schrems II decision was not the first time that the court decided on transfers and the transfers framework between the EU and the US in particular. So there was a number of concerns expressed already before by the court in Schrems I in relation to the surveillance regime in particular that exists in the US. And this criticism was perhaps particularly strong following the Snowden revelations. But let's not forget that certain dissatisfaction with the Safe Harbor framework actually already existed much earlier than the Snowden revelations. So when you look at what the data protection regulators from Europe were saying about Safe Harbor already from the very beginning of this framework, you would see that there wasn't a great deal of confidence that this instrument actually provides sufficient guarantees for the Europeans' personal data protection in respect of the processing in the US. So from that perspective, the decision in Schrems II maybe wasn't entirely a big surprise. And I have to say that for those who were watching this space very closely over the past years, perhaps even the Schrems II decision wasn't such a big surprise either. And there are several concerns again and several shortcomings of the US system that the court pointed to, two of which were judged so critical that indeed, in the court's view, this decision, this framework had to be annulled once again. And that's indeed, first and foremost, the broad scope of the US surveillance programs and the lack of meaningful limitations on the US side, on the US authorities' capacities to access personal data that are transferred from Europe. And second, lack of effective redress for EU data subjects in this context. And these once again are not new concerns, not new issues, but once again, perhaps since Snowden revelations, the issue of government access to data, of surveillance, obviously has taken a central place in the considerations of the Court of Justice. And just to reassure our viewers, especially those from the US, it is not the case that the Court of Justice is uniquely looking at the US legal system in this context. There are other cases pending before the Court of Justice today where government access to data and the existing legal frameworks, both in the case of law enforcement and in the case of national security, so intelligence services access, are scrutinized, are being looked at, and we actually look forward and expect the court to release important judgments in this context even tomorrow, which is Tuesday, the 6th of October. So this issue is simply very crucial for the court, and from this perspective, not surprising that it received so much attention in the Schrems II case. Now, you ask about the perspective for a new Privacy Shield 2.0 enhanced future framework. I think it's the million-dollar question. Obviously, I would say that from my perspective, given the importance and the sheer volume of transfers that are taking place between the EU and the US, indeed, a new adequacy framework would be the ideal solution, possibly the only one that would provide the necessary stability and legal certainty. At the same time, I would personally think that if there is such a possibility, it would be more of a long-term vision, long-term solution. So certainly not in the short or medium term. Why not? Well, because despite the fact that the European Commission obviously seems quite committed to achieving a new adequacy framework agreement with the US as soon as possible, and we all know that the talks have already started, at the same time, the concerns that have been raised by the court in its judgments are so serious and of such an important systemic nature that it seems very difficult to imagine that it would be possible to achieve a stable adequacy finding without a meaningful change in the US legal system. And here again, it would have to achieve or remedy the two shortcomings that were identified by the court in particular. So the lack of remedies for EU data subjects, and possibly also some kind of limitations or better defined framework for access of agencies to the data in the first place. And personally, I think that in particular, the second aspect might be rather difficult, and I do not see this happen in a very short term or medium term perspective. Let's hope for this. But certainly from the point of view of European data protection regulators, Privacy Shield 2.0 or 3.0 would not be a realistic perspective without a meaningful change in the US legal system.
Thank you, Anna. Really interesting insights there. Yes, I mean, these things do take time, don't they? Safe harbor when it fell, it took many months before the Privacy Shield was up and running, and of course, it had been in the works for a while. So yes, I suppose no surprise, although disappointing that there isn't a solution immediately on the horizon. But the practical implications of this decision, Linda, although financial services firms are not able to sign up to Privacy Shield because we're regulated by different entities, so it is not the financial services firms who are directly impacted by the decision, but obviously we're massively indirectly impacted because so many providers, something like 5,000 or more entities in the US have signed up to Privacy Shield. Could you just tell us a little bit about what the practical implications of this decision has been for the financial services sector, the removal of the Privacy Shield? And do you think that standard contractual clauses can fill that gap?
So I think the impact of the decision has taken a while, I think, for people to understand what it truly means. And I think one of the things that I'd like to say from the outset is that we need to take some breath, we need to calm, and we need to approach this as sanely as we can, facing what the reality is. I think the fact that we ourselves are not directly impacted by Privacy Shield directly because we don't sign up to it doesn't alleviate the responsibility on any company that has a service provider that is signed up to Privacy Shield. And because the court invalidated the Privacy Shield, we also have to remember that our service providers themselves are still bound by US law with respect to their side of the Privacy Shield as well, because it's a two-sided approach to it. In terms of what we have to do to ensure that we comply with our obligations with respect to data protection law and that our compliance frameworks are as robust as possible, we have to understand that we now have to find an alternative to Privacy Shield for those service providers. And from a practical point of view, what you have to look at is how many contracts with service providers who have offered me data protection assurances on foot of Privacy Shield do I have? So the first thing is locate those contracts. How do you do that? Well, one of the things, if you're doing your data protection compliance diligently and you have your all your ducks in a row, is to look to some of the things that you already have in place, such as your Article 30 record of processing activities. And that will show you not just what you're doing with personal data, but also where you are transferring data. So you may in fact be able to use that as not as a shortcut, but as a strong document to support your assessment as to which contracts are going to be problematic because they're based on transfers to the US on foot of Privacy Shield. Once you've identified what those contracts are and with whom they are, because as Anna said, you know, this decision isn't just about the US in practical terms. It may be, the emphasis might be on it in legal terms on the US because of the nature of the case. But if we're looking at this practically, and we should, then identify then which contracts are going to the US on foot of Privacy Shield, then look to see what alternatives do we have. In many cases, the alternatives that we have practically are standard contractual clauses, like you say. Maybe for other types of scenarios, binding corporate rules might work, but they won't in situations involving third-party vendors who are not within the same family of companies as the exporting entity. So we need to move from our transfers of data to the standard contractual clauses framework. And that's where it becomes not so straightforward. And the reason it's not so straightforward is that the court did not declare standard contractual clauses invalid in the same way that Privacy Shield was declared. But what it did point out is that it re-emphasized the huge responsibility on an exporter, a data controller, who's exporting data to any country using standard contractual clauses. And what it said is that please be careful when you are transferring data to any third-party country outside of the EEA, where those laws may not provide for the same protections. So from a practical point of view, what does that actually mean? Well, first off, you need to get your documentation in place. Do you know what standard contractual clauses you are going to use to enter into an agreement with this vendor? Have you identified what the nature of the relationship is? Secondly, then, how do you implement that into your agreement with that vendor? And that's going to open up negotiation and negotiation talks and times. Thirdly, from a practical point of view, we have to remember that the SCCs that we have, the standard contractual clauses provided by the Commission, are considerably out of date. And we are awaiting new contractual clauses from the European Commission to bring them up to a GDPR level. So there may be some practical issues there as well about interim solutions pending the European Commission giving us this new set of standard contractual clauses, which may help in terms of short-term solutions for looking at this. But from a substantive point of view, what do the standard contractual clauses actually do? What they do is they say, as an exporter, me, a bank, a financial service provider, somebody in our industry, is binding over the recipient of the data that we are sending to obligations that we are going to be responsible for based on our obligations under the law, and that we expect you, as the importer, to adhere to that. And we will carry out assessments as to whether the environment in which you are in, which you will tell us about as well, because we should have an ongoing discussion with each other on an ongoing basis, whether or not that is still conducive to privacy protection of a level that we need to get from the recipient company when we are sending data there. So in simple terms, that means we essentially step into the role of an adequacy assessor, and we have to carry out mini adequacy assessments about each country to which we are sending data, and not just each country, but each type of entity to which we are sending data, because the risk in terms of the types of surveillance laws that cause the problems for the court in the Schrems II case isn't the same for every type of service provider. So in practical terms, what I think we have to look at is, number one, breathe. Number two, identify that this is not a legal issue per se. This is a combined approach that we need to look at. We need to understand our contracts. We need to understand who we're contracting with. We need to understand how we are going to implement this from a practical point of view, knowing that there are going to be more contract negotiations coming down the line with the SCCs as revised, and we still don't know what they are. We also need to remember that it's regulators as well who are part of this solution, who are part of this relationship that we have. And our own European Data Protection Board has said that regulators are part of this solution. So we're still waiting to get some advice from the regulators about what additional safeguards they might see as acceptable if the standard contractual clauses that we currently have at the moment, in our view as a data exporter, don't match up with what we are required to provide under data protection law. And that is the issue. Under standard contractual clauses, under the law, we can actually put in place additional safeguards. This could be technical safeguards, legal safeguards. There could be some other operational safeguards in place. The problem from the Schrems II decision is that they haven't been identified. From the regulatory point of view, there isn't a consensus approach across all the data protection authorities either. So before we can do a full assessment, and this is a full risk assessment, which is why I'm saying it's not just purely a legal issue. Before we can get to a point where we can say, well, that's great, now we've got all that fixed, we've got our new SCCs in place and everything is fine, we need to understand our risk. We need to understand the risk for each contract for which we are sending data to a jurisdiction outside of the EEA. And I think, to be fair, I think that's a huge undertaking, but an undertaking that we are supposed to be doing one way or the other, which we probably already do. when we make our assessments about when we are transferring data. So I think this is about just taking a pragmatic approach to understanding where my risk lies. And that's really, I think, where our starting point is, and that we're not alone, that we do need the support and help of our regulators and of our industry in doing this.
Thank you, Linda, for those insights. That was actually really very interesting and practical. I suppose you give me some hope, because the real concern is that large firms with departments who do transfers regularly are used to following that sort of approach, but the challenge is really going to be for SMEs. And as we know, 90% plus of all businesses in the EU are small and medium-sized enterprises. And this is quite a complex area to navigate. And certainly when you're having to make assessments about surveillance laws in third country jurisdictions, it's not necessarily a skill which rests in-house. And so the question is how will firms practically embrace these obligations and challenges going forward in a way that's technology neutral, accessible, and also reflects the great diversity of organizations out there. Not all firms are financial services firms, and everyone needs to be doing this. So thank you. That was actually very interesting, and I think we're all waiting for that European Data Protection Board and other guidance to come through. If I can shift gears a little bit and come to you, Anna. One of the concerns about the Schrems II decision and Privacy Shield falling is that some of the reasons behind that, of course, is the concern around mass surveillance and the lack of access to effective remedies that individuals may have. I think the big question for many people is, where does this leave the adequacy assessments which the EU will be re-looking at over the next 2 years as part of GDPR? If the US, a very significant global democracy, is found to be lacking, and they have lots of privacy laws popping up. They've had COPPA and HIPAA and Gram-Leach Bali for many, many years. There's now CCPA, there's proposals for other privacy legislation. There's 13 other states that have got laws underway. It's not that it is a privacy vacuum. There is a lot of privacy requirements already in the US. But where does this leave the adequacy assessments as the EU relooks at the other adequate jurisdictions on a go-forward basis? And do you think they'll survive this new scrutiny as a result of the Schrems II decision?
Well, thank you, Vivian, for this question, which is obviously quite a complex one. A lot of different elements to address here. First of all, I would say that obviously the adequacy assessment or reassessment has been ongoing already, and the first and foremost reason for this was the entry into force of the GDPR, while the existing adequacy decisions were still based on the old directive. So that there in itself there was quite a lot of work for the Commission to do already to reassess what was decided before. Certainly, the decisions of the court in Schrems I and Schrems II in particular provide further elements of what the Commission should also be looking at. So to not only, just to give your examples, not only to look at sectoral or other legislation that there might be, but also, as I said before, look at the issue of government access to data, including intelligence services access to data, and the issue of remedies, which I think it's fair to say have become particularly important and crucial to this analysis post-Snowden and post-Schrems I and II. So indeed, these aspects may not necessarily have always been taken into consideration in the past assessments. And here again, I think we need to make a clear distinction between data privacy laws as such, especially sectoral ones, It is true that for the US in particular, there are indeed various initiatives or sometimes even laws, such as in California, at state level, at sectoral level. But it is still one of the jurisdictions without a baseline, generally applicable data privacy law at federal level, which frankly is looking more and more like an outlier at a global scale, where you see that over 130 jurisdictions now have cross-cutting data privacy laws enacted. Some of those, not all, are loosely modeled on the approach of the GDPR or the approach of the Convention 108 of the Council of Europe. Brazil has adopted a law like this, as you know, quite recently. India is moving in that direction. Personally, I believe that I would hope that with time, the US would also move to the direction of a generally applicable baseline data privacy law to be adopted at federal level. And who knows, at least to some extent, that could facilitate or positively influence the adequacy assessment overall, because let's not forget that there is more to an adequacy assessment than just government access to data and judicial remedies. But on this latter point, it is true that the US system, as clearly identified or assessed by the Court of Justice, is not adequate today. And the Court of Justice had sufficient information based on the 3 weeks of hearings before the Irish High Court, including input by the US government, including amicus briefs submitted to the Court of Justice on what the US law says in this respect. So here, in relation to the US legal system, we currently have quite a clear assessment by the Court of Justice itself that it is not adequate on these 2 points. But obviously the situation might be different in other jurisdictions. And let's not forget that the United Kingdom is currently also undergoing an adequacy assessment by the European Commission. But already here, I believe personally that at least the RIPA system and the court remedies that are available there seem certainly provide a higher level of protection to individuals than what we have in the US system. So obviously I'm just speaking for myself. I'm not speaking for the EDPB or for the European Commission. But it seems that it might be possible to provide for legal guarantees and for meaningful remedies, even in a jurisdiction that itself also obviously has a certain surveillance capabilities, and this is widely known. So it has to be, I'm afraid, a case-by-case assessment, and it will be a careful case-by-case assessment, first of all, by the European Commission. But then in each case, as you know, the European Data Protection Board, the EDPB, of which we as EDPS are a member, will also have to be consulted on each adequacy finding and provide its opinion to the Commission. So we very much look forward to this work. But again, it is certainly a long-term project. And not something that can be done in the next weeks or months. And just, if I may, come back very, very quickly to what Linda was saying just before about the regulator's role, also in relation to the SCCs and the advice to companies on the supplementary measures. Yes, of course, we are very much aware of the pressure and of the need on the ground to provide more clarity and more specific advice than what was included in the court's judgment, because let's be honest, there isn't much. The court simply said that yes, it is possible to still use SCCs in principle, but provided that there are supplementary measures, at least in some cases. So here already we have worked a lot, and we continue to work with the EDPB to promote legally sound yet pragmatic approach to say that the SCCs are indeed not excluded for transfers, not even for transfers to the US, we would say, but on the condition that there are supplementary measures in place. And of course, now it's the race against the clock to issue those measures as EDPB, so that there would be a common European approach to these issues. But I have to stress that there is also obviously a close link between those supplementary measures and the new SCCs that the Commission is working on. And so we would certainly hope that the Commission can release at least a draft version, or let the EDPB let us know what they have in mind for the new SCCs, because it would be very, very regrettable if the two exercises, supplementary measures on the one hand and the new SCCs on the other hand, somehow were developed in isolation and with no coordination, because obviously there has to be close links and coherence between those two sets of rules. So this is the work which is going on right now in the coming weeks and months, and hopefully very, very soon there will be some information coming from the Commission on the SCCs and from the EDPB on the supplementary measure.
Thank you, Anna. And you actually answered the catch-22 question, which was, with the Privacy Shield down, what are the alternative mechanisms to send personal data to the US? The obvious one is to use standard contractual clauses, but given the basis of the decision, it does actually beg the question, can you use standard contractual clauses to the US? So thank you for that clarification. That was really helpful. Linda, could I turn to you next? And this is a question which we received from our viewers. The question is how are financial institutions based in the EU planning to share information in the absence of an adequacy decision? I'm assuming that's a UK adequacy decision. Mm-hmm. When we're focusing on the financial institutions sharing information, we're thinking about KYC information, transaction information, the financial crime information, funds transfers, investigations, etc. So what are the mechanisms that you're seeing are being used to make those transfers in the absence of a UK adequacy assessment?
So I think we need to understand how and when these types of requests for transfers are made, and when we have to make them ourselves. Some requests are going to be required as a matter of law, and in those situations it may not necessarily be a systemic transfer of data. So there are within the chapter in the GDPR derogations that allow for the transfer of data where it's on foot of legal compulsion, so where you're required by law to do this. There are some instances where maybe consent may be required. I'm not so fond of consent myself as a particular basis for the transfer of this type of data, because it's very, it's quite difficult to meet a very high threshold level of definition of consent for the individual. And I think what we're looking at here is a rebalancing of things. So there are situations where the transfer can be done on basis of derogations. Derogations are done on the basis of necessity and proportionality in that regard. But I think if you're looking at something where with AML, KYC, which is much more systemic, we have to go back to what do we really have left? And what we really have left are the same options, which are things from a data protection point of view. We're looking at SCCs, we're looking at binding corporate rules, we're looking at the extent to which adequacy can be there, which, as we know, isn't quite there yet. Like Anna, I think you have to, like Anna was saying about the UK versus the US, I think you have to look at this in terms of risk, which is what the GDPR asks us to do, which is to take a risk-based approach to how we are transferring data. The UK will be is outside of the EU now. We treat it like every other country, so we have to still follow our full assessment in making those transfers. So I think we have to look at it from that point of view. So depending on who the recipient is of the data will determine the type of measure that we can use in order to carry out the transfer, the type of mechanism. In the case of sending it to other parties, we look at standard contractual clauses, to sending it to any financial service provider that does have a base within the UK. You can potentially look at binding corporate rules. That's not practical if you don't already have binding corporate rules, in all fairness, because you can't actually get a binding corporate rules decision like that. And for anybody who has tried to get it, it's quite problematic. And for other situations, then we just have to look to how, with conflict of laws, we're going to have to look at that, and that unfortunately will go to the legal department.
Thank you very much. Another question for you, Anna, actually, which is
Vivian, excuse me, may I just add something on the UK situation? Because if you allow me, I mean, of course, there is still not an issue until the end of the transition period, because the withdrawal agreement still covers that, and obviously it might not be super reassuring because we are talking about practically 3 months. Until the end of the withdrawal period. But just to say that, as you know, the Commission has committed to proposing the 2 adequacy decisions, one under the GDPR, the other one for law enforcement. And I just would like to stress that from the EU side, there is still commitment to achieve those, even though maybe the one on law enforcement seems to be more desirable for European partners and maybe also for the UK government. I don't know, hard to tell. But just to say that this work is ongoing, so not all hope is lost yet. But indeed, I would certainly agree with you to say that 3 months is not a long time. So perhaps for those who anticipate that transfers will have to continue already from January onwards at a larger scale than, for instance, derogations would allow for. Indeed, this might be a good moment to start putting in place some fallback measures and backup options to be able to fall on them. Also, maybe in the not unlikely case, if adequacy arrives, but slightly later than the 31st of December, which we cannot exclude either. Thank you very much.
Thank you, Anna. And that's an excellent point. I think, firms hopefully have already been thinking about options in a best case and a worst case scenario and putting them in place. Obviously, the UK has stated that they would not put in place any additional requirements for transfers of data from the UK to the EU. But on the EU side, firms need to be ensuring that they have SCCs or other mechanisms in place to continue that transfer post the transition period. Let's move into a very topical issue. We're hearing an increasing amount about data localization. And my question for you, Anna, and this is our last question, is could data localization be a solution for Schrems II? Your thoughts?
Well, obviously, data localization is not a new concept. There is a number of jurisdictions around the world who have been pushing for data localization. It would seem for all sorts of other reasons than data protection or even data security. That would be Russia, China, some others. I have to say, at the EDPS, more generally, we are not huge fans of data localization. I also do not subscribe to the reading of the Schrems II judgment that would mean, from now on, data localization within Europe is the rule and transfers are the absolute exception. I do not read this ruling in this way. I do not think it would be in line with what the legislator intended in the GDPR, where there is the entire Chapter 5 and still scope for transfers. What I would say is in line with what Linda was talking about before. So, the need to really consider the transfers as a meaningful operation and to assess the risk and to be aware of what you are doing. So I think what the court is trying to say is, yes, transfers may still be okay on the condition that you kind of know what you're doing, that you understand the implications, because by transferring is not as any other decision to store the data wherever. It actually has implications for individuals' fundamental rights. So it has to be thought through, and it has to be, it has to happen within a clear framework of statutory and other meaningful safeguards. And so I would certainly not support the interpretation by which the court now requires us to put up artificial geographical borders and only talk in terms of data localization. But of course, especially from the regulator's perspective, it is important to make sure that the data is protected. So we would certainly look or think in terms of working with responsible entities who find legal, organizational, technical means to ensure that the level of protection follows the data, so to speak, and which frankly has been the underlying principle around international transfers for a long time. But it seems that it took Schrems 1 and maybe even more Schrems 2 to crystallize the minds and to get the message really across to people that data can move across borders on the condition that meaningful protection follows in some way. I also would like to say, however, that data localization is not entirely a concept which is foreign to European data protection law and regulators. In a different context, you may remember the Court of Justice 5 years ago or so in the DRI judgment, which annulled the Data Retention Directive, already hinted that in some context, well, in that context, it was storage of the electronic communications metadata that had to be retained by telecom operators following that law. And the court hinted that in the case of some specific, very sensitive databases, such as this one, the ultimate solution might be localizing the storage within the EU in order to allow meaningful supervision by data protection regulators on that. And I have to say that as EDPS, in our enforcement practice, which predates Schrems, we have also identified such instances where we said to the controller that we consider that here, in this case, data localization might in fact be the preferred solution. But at the same time, we have to consider that in some cases, simply storing the data in Europe does not shield it from access by foreign authorities, where extraterritorial and other rules might still oblige operators to grant access in some cases. So, well, a complex issue, but I think data localization can play some role in specific, well-defined cases, but it is not and should not be considered as a silver bullet solution, and it is not the desirable outcome, I think, of the Schrems 2 reading from the point of view of data protection regulators, and certainly not the EDPS.
Perfect. Thank you very much.
I'd have to agree with Anna. I share those sentiments strongly, and I think data localization is an answer for a completely different question. and not the question that we're trying to resolve on the back of the Schrems II decision. And if we go to what Schrems II is really about, it's about individuals, and it's about protecting their data and giving them their rights. And I'm not sure how data localization actually addresses that directly in all cases. To Anna's point, it's not a solution in every situation, but also the impacts of data localization are quite worrying, because to your point earlier, Vivian, about the disproportionate impact on SMEs, data localization would impact SMEs much more disproportionately than it would for larger companies, especially in financial services, especially in an industry where we are encouraging innovation. We are encouraging more direct links between individuals and their data in a financial services context. And I think that it's expensive to do data localization. The court itself referenced recital 101 of GDPR, which talks about how important international data flows are for economies, for the transfer of data, for meeting citizens and residents and individuals' requirements. It isn't just data protection that data localization impacts. There are competition concerns there as well. There's closing down of borders, and there's creating borders even within the EU, which seems counter to the overall approach. And I suppose then the other issue with that is the reprisal actions that can have from other countries as well. And I think if you look to what it is that we're trying to solve, and to Anna's point, even holding up data and shoring it up within the EU in certain pockets doesn't protect it from being legally and lawfully accessed in certain situations, not just by law enforcement entities under legislative regimes like the Cloud Act, but also companies who may in fact have to give access to their customers outside of the EU and to data that's held within the EU as well, and in terms of how services operate. And where that all works. So I think that we need to be, we just need to be realistic about what a data localization law can actually solve. And I certainly don't see it as a Schrems II solution. But to Anna's point, every solution like this can have its discrete uses, but certainly not a general approach.
Okay, terrific. Thank you so very much. Unfortunately, we're now out of time, but my goodness, we certainly did a journey through the topical issues for financial services and data at the moment. So the impact of the Schrems II decision, what that means for data transfers between the EU and the US. There is potentially light at the end of the tunnel, but we're still very much on that journey. Standard contractual clauses survived, but they are subject to additional measures, and it's very much watch this space, because standard contractual clauses are going to be changing. It's been in the pipeline for a while. And then we're looking forward to the guidance that's going to come out, which will help everyone, both large organizations and SMEs, to navigate how they manage their international data transfers going forward in this evolving environment. But I think it's certainly an important issue that we need to keep an eye on, a very close eye on, because data is what is driving our economies. Data is digital, and data is moving across borders. So we need to secure it and protect it, and use the mechanisms that are available to us. And those mechanisms are changing to meet the changing environment in which we are currently operating. So thank you very much, Anna. Thank you very much, Linda, for your insights today. That was incredibly helpful and interesting, and I hope you enjoy the rest of the event. Thank you very much and goodbye.